Good afternoon. Welcome everyone to GT Jeopardy session this afternoon. My name is Cheng Pham, and this is my colleague Dan Blanchard. We're from the Boston office of international law firm Jeopardy. And for those that may not know, Jeopardy is about 1,800 lawyers with 37 offices globally, and we do pretty much everything in all areas of law. And with respect to the Boston office, being in the center of innovation, we work with a lot of technology companies, many in the emerging tech, such as video gaming, and we have a number of video game interactive clients that are doing some really amazing things in this space. And when we talk to a lot of these video game companies, many of them are in the early stages. As they look to form a company and commercialize their technology, we often get asked a couple questions, two of which usually deal with corporate and the other is IP. So when we got the opportunity to speak at Boston FIG, we thought that might be good to focus on these two areas, as perhaps many of you will have similar questions. And so we figured we make it fun and create a game Jeopardy just so that we can address a number of the issues that you guys may face. But briefly about myself, again, my name is Cheng Pham. I co-chair the Boston office IP practice, intellectual property practice. I also co-chair the firm's emerging tech practice globally. My bread and butter is in the intellectual property area, and there's just a lot of hand-holding that I do with a lot of clients that I work with. What I enjoy doing most is trying to understand my client's business and then understand where they want to go with their business and help them establish as well as exploit their intellectual property for high-value commercial opportunities. In addition to what I do, I work very closely with numerous accelerator and incubator programs in the Boston area in mentoring as well as advising these startup companies. I'll let Dan introduce himself a little bit.
So I'm Dan Blanchard. I'm a corporate lawyer. I work frequently with Cheng. I work with companies from very early stages all the way through their life cycles and when they're larger, more mature companies, including companies in the video game space. So I advise clients on a day-to-day basis on corporate structure, whether to be a corporation, how to raise money, and sort of how to take their products to market.
Great. So as you can see, this is our version of Jeopardy, and as I said, we like to call it GT, which stands for Green Jeopardy, GT Jeopardy. And there are 5 different categories, roughly covering a different stage of the life cycle of a technology company. And then there are 5 questions in each category that hopefully will touch upon various issues and considerations that's relevant to an emerging tech company, like a video game company. In terms of how we're going to play today, we're not going to have 3 contestants on here. You guys are all contestants. You guys can just raise your hand, pick a category, pick a question, and then we'll go from there. Okay? I don't know if you guys know what these categories are about, but just let me briefly explain what each is about. Bootstrapping, that's really the beginning stages of for a company. This is when a company starts with very little capital. The entrepreneur is said to be bootstrapping when he or she attempts to found and build a company from personal finances or from very little operating revenues the company may have. Next category is Valley of Death. This is usually the stage or the period from the formation of the company until it gets some traction, and when investment must be made to sustain the business. Due diligence. Due diligence actually can happen throughout the life cycle of the company. It's really an investigation or an audit for potential investment or acquisition. Due diligence serves to confirm all the material facts, including the company's asset, in preparation for the investment or acquisition. But today, we're going to focus on the investment stage rather than the acquisition stage of due diligence. Early retirement, that's the exit stage for a company. Pokery, we couldn't fit in, a lot of the questions that we ask, and we feel we throw them all in appropriately. And so, those are the 5 categories. Yeah, 5 categories. And so, let's play. Okay. So who wants to pick the first question, and which category it's going to be? Okay, you.
Bootstrapping for 30.
Bootstrapping for 30, okay. This, so the answer is, the documents one files with the Secretary of State to create a corporation. What's the question answer? You don't know? Okay. Okay.
So it's a charter, certificate of formation, or articles of incorporation, depending on the state you're in. It's basically one of the basic items that you need to file to create a corporation. On day one, you want to have a corporation, you want to start your own business, it's usually a good idea to file a corporation, whether that be in Massachusetts, Delaware, or wherever, to protect yourself and your co-founders if anything were to go wrong in the future.
Okay. And usually you probably want to create a corporation or at least some sort of entity to fit in all the assets that you're going to be creating early on, so that no one founder will be owning each of those the assets. So we'll not get to that in a little bit. Okay. Who else wants to ask a question? Just pick a category.
Let's do Valiant Death for 20.
For 20, okay. Okay, the answer is documents that can help to establish ownership of the innovation by the company. Yes?
Is that certificate of originality?
Not quite.
What is patents?
Close. The answer is, mostly it's an assignment, an employment agreement, or an employee handbook. So the assignment is typically a document that sets forth the transfer of title and rights from the inventor or an employee of a company over to the corporation. So in the US, for the most part, when you innovate, you own the innovation. But if most companies want to own that innovation, a lot of them will put that in an employment agreement. They'll have a provision in there. I don't know if any of you work for a company or not, but just go back, take a look at your employment agreement. There's usually a provision in there that says, as an employee, of this company, whatever you come up with, whatever you innovate, you hereby assign that innovation over to the company. And if they don't have that, and then, to the extent that you're working and you invented something, and then the company files for a patent, they'll force you to file, sign a document, assigning the rights and title over to the company. Does that make sense? Okay. Let's go back to the board. That didn't work. Okay. I don't want to jump up.
Anybody else?
Who's driving with 10? Oh, sorry.
Oh. Okay, why don't we get you next, and then
You say potpourri for 10.
potpourri for 10. Okay. Okay, this acts as an identifier of goods or services. Take a guess. Okay. Well, the answer is, what is a trademark? Okay. A trademark is one, one of the areas under the IP umbrella. Just briefly, IP covers patents, trademark, copyright, as well as trade secrets. For a lot of the early stage company, video game company, trademark is actually a fairly important strategy, because when you create a game, a lot of times you want to sell a game. What you want to do is you want to brand that game. And the naming of the game or the marking of the game is typically covered under a trademark. It's fairly easy to do. You can go on the USPTO.gov site, go to the database, type in, a mark that you want to, see whether or not someone is protected. A list will come up, and there's nothing similar, it'll say nothing, and that, nothing's available. And you know that no one else has that mark. And you can just follow the instruction, it's fairly straightforward, fairly inexpensive in comparison to it. Okay. Mr. Patriot back there.
Yeah, I think it was 10. I think 10. Bootstrapping for 10.
Bootstrapping for 10. Oh, that's been, has that been?
I don't know. That's what I thought it was.
Oh, okay. Okay, I really like this question. The individuals most likely to fund your first company. I'm sure many of you have heard this. Just blurt it out.
It's a saying.
Angel investors?
Yeah,
We're pretty close.
yeah. Oh, what did you say? That's really close. So the answer is, who are friends, family, and fools. The 3 Fs. And you want to explain a little bit?
So that's, obviously the saying that, when you've got a hope and a dream and an idea, and really not much else, the people who generally give you money are your friends, family, and, fools. They joke that it's the 3 Fs of early angel capital.
But let me do this. I mean, after each of these questions, if you guys have questions that you want to ask us with respect to this particular question or answer, feel free to do that. We'll be more than happy to do that. Okay? Okay. You had a question before.
All right, somebody already took it, but how about Valley of Death for 10?
For 10, okay. The answer is the term for a very small round of venture financing. Very small.
Seed?
It's good enough. It's the same.
Okay.
It's the same.
There you go. You got it. What is a seed or an angel round?
So a seed or an angel round is a small round of financing. They generally, the lines sometimes blur. We're talking more, 100,000 to maybe 300, 400,000. It's debatable where it is. Generally, they're not looking for as much control of your company. They're just sort of getting you off the ground and giving you a chance to prove your concept and see if you have what it takes to, take it to the next level. Generally, a seed round will precede a formal A round or a larger venture round, where people will really start scaling their company.
So you guys know the difference between seed, angel, and venture? Maybe you can talk briefly about that.
So seed and angel investors in the Boston area in particular, they tend to be, sort of groups of people in the industry who like the idea of helping out people who are just starting. Venture capital firms are professional funds that generally are focused on a particular sector and are looking for high growth companies, and that's what they do for a living full time. Seed and angel round tends to be, individuals who have full-time jobs or something else, and then they like to, do this on the side.
So if you're a startup video game company and you want to get your company off the ground, it's not likely that you're going to go and talk to a venture capitalist to fund it. Okay. It's too small of an amount for them to consider investing in your company. Okay. Are you writing this down?
Yeah,
Oh. You guys ready to go ahead.
Bootstrapping for 40.
Bootstrapping for 40, okay. Okay, now, this is one of the longest kept trade secrets. What'd you say?
How could we answer formula for Coca-Cola?
That's perfect. It is. And so, as I said before, IP, an area that an umbrella that covers a lot of protection for intellectual property for an early stage company. And with a lot of early stage companies, when there's not a lot of money, they have to consider, how to protect their intellectual property. Should they go the patent route, or should they go the trade secret route? A patent actually is fairly expensive. Traditionally, what you think of a patent can cost you about, $10,000 to $15,000 just to get a lawyer to write the application, and then filing that costs you another $1,000 to $3,000, depending on how thick the patent is. And then after that gets examined by the patent office, and then that's about $3,000 to $5,000 per round of examination, depending on how complex or how good your innovation is. And so a lot of early stage companies usually don't have the resources to pursue a patent. And so some of them will consider protecting their innovation through trade secret. And when should you consider protecting your innovation through trade secret? You need to ask yourself, one of the things you need to ask yourself is my innovation easily reverse engineered? If it is easily reverse engineered, then might as well file a patent application, because a patent application discloses your innovation to the rest of the world. If you can keep your innovation secret for a long time, like Coca-Cola's formula, then keep it as a trade secret, because that's going to give you the business advantage or competitive advantage that you need. In the video game area, the source code may be kept as a trade secret. How to play the game could be, or what the game looks like, and how you want to play that game could be pursued through patent protection. So you can look at each aspect of your video game and figure out and determine whether or not it should be protected under patent or under trade secret. Okay? This is not looking well.
For the bootstrapping, we only have 50 left.
Oh, really? Why is it not looking? We're lawyers. We're not very good with technology like you guys. Okay. Pick a category. Exterminate. Why do you pick a category?
Valley of Death for 30.
For 30, okay. The answer is the document provides terms and conditions upon which equity is granted to employees. Anyone?
Contract?
It's a type of.
Yeah, it's a type of a contract. That's good. Okay, we'll.
So this is what is an equity incentive plan and or a stock option plan. This is particularly important for startups because, generally speaking, if you're a startup company, obviously you don't have a lot of money. You don't want to, if you have gotten a seed round, you don't want to burn through your cash too quickly. So these equity incentive plans or stock option plans are essentially a means by which you can grant options to potential employees so that they're willing to, it's a way for companies that are starting up to give employees an upside if the company takes off to compensate for the fact that you can't pay them as much as some of the larger companies in the area. So it's a way that startups can sort of attract talent from the established players in their fields. So in generally, equity incentive plans, they have vesting provisions where if you stay for 2 years or 3 years, they vest every month. Or there's a cliff where if you stay for 1 year, you get 1/3 vested and then monthly thereafter. There are various milestones if you're working on a game and you take that game to market. The option plan may say that everyone is granted X number of shares once the game goes to market. There's just a whole variety of ways that This is sort of work to incentivize your employees, to make them want to work for companies where they can actually get paid more in cash, but here you can, startups generally like to give away equity.
So this happens a lot in Silicon Valley.
Yes.
And maybe you can give some examples of some
So,
companies that where employees, you know.
I mean, there's a slew of companies in the Silicon Valley, in the greater Boston area, where there are these early employees who, they got into a company early enough, and they've been loyal to the company, and they have stock options that arguably weren't worth much. If you grant someone, if I start a company tomorrow and I grant everyone in this room 10 stock options, but the company doesn't do anything, we don't make any money, they're really not worth much. If that company ends up becoming the next Google, we'll all be pretty happy. So it's just sort of a way to get buy-in for all of your employees.
Does that make sense? Okay. Bootstrapping to 50, okay.
Closing out the category.
Okay. The answer is an agreement common among the founders of the company that outlines how the shares of the company will vest over time. So very much along the lines of what Sam was. Yeah. Okay. I'm just going to show the answer here. What is a founder's agreement?
So a founder's agreement is, I was just talking about stock option plans and equity incentive plans. Those are for your employees. That's at the later stage. We're talking value debt at that point. Now we're talking bootstrapping. Founder's agreement is an agreement that's common among startups. With, if you have 2 founders or 3 founders of a company, you want to make sure that you don't give each of you 1/3 of the company, and then 2 months later someone gets another job or gets bored and decides they want to move on. The 2 people who were left behind, this has happened historically, where 2 people are left behind, they work around the clock, they're killing themselves on this company, and they make it super successful. And the 3rd person, who was only there for 2 months, because they were just granted regular common stock, still own the regular common stock. A founder's agreement is an agreement where all the founders are granted restricted stock that vests over time based on how long they stay with the company. So it's the initial ownership of the company, making sure that all the founders are committed to the company and their shares only vest as they stay employed with the company. It's a similar principle to the stock option agreement that we talked about just a moment ago, but it's for the founders specifically, and the initial ownership of that company.
So I think what it does is it protects the guys that are working hard so that they don't.
It protects certain founders from other freeloading founders.
Yes. Okay. So now we just have to remember that category is done. Okay.
All the other categories are still open.
How about you?
Early retirement.
Oh, early retirement, okay. Okay, the answer, the process by which a corporation's shares are first sold to the public. Fantastic.
Yes, so an initial public offering is a huge event for a startup company. I mean, everyone knows the stories, everyone's heard of Facebook's IPO. It's happening later these days, but technically an IPO is when, all the founders, the early venture capitalists, the early angel investors, even employees that have stock options, they go and they list the company, generally on an exchange, New York Stock Exchange, NASDAQ, and after that happens, which is a huge event in a company, you have a public, anyone in the country can go and open their brokerage account, and you can go buy a share of Facebook now, you can buy a share of that company. It provides liquidity, which means that for all those people who have had their shares vested over time, suddenly they can go, register those shares, and sell them off to the public whenever they want. Because if you think about it, before the IPO, if you own 30% of the company, you have to find someone to sell them to. After the IPO, it's easy to sort of sell shares as you go. So IPOs are a massive, massive step in a company's life. It's obviously something people celebrate.
It's a sign of success for the company, but not, it doesn't happen often. So what do you think is the percentage of company that, tiny?
Yeah, I would say less than 0.5% of companies IPO. And just to give some color to that, what's happening in the world these days is companies that 10, 15 years ago likely would have done an IPO now realize that some of the bigger companies who already are public are willing to acquire them. So what used to happen is you have a group of founders, they're really passionate, they want to take their company public, and they would take it all the way public, and then they continue as an independent company. What you're seeing a lot more frequently these days is companies are successful, they're making money, everyone's happy, but rather than go public, they get acquired by a larger company that does the same thing they do, and they become a division of that company. That's something that founders think about. It's a strategic.
And I think that latter example happens more often within the video game company.
Much more often.
You know, a video game company going IPO.
Yes.
Okay, what was the last one that went IPO? I think isn't Candy Crush.
Candy Crush.
But it's a company that has essentially one game, right? And it went IPO around this one game. I'm not sure how long that's gonna.
And the other thing to think about with companies that go public is that once you're public, hedge funds, activist investors, all these financial types start acquiring your stock, and they sort of try to pressure you to do this or close this business line, do this, do that, and some people just they don't want to go through the process anymore. That's why you're seeing a lot of these companies that are resistant to going public. Okay.
Maybe what we'll do is we'll pick a few more questions, and then we'll open it up for questions and answers, because I'm sure you guys have specific questions that you guys want to ask in connection with your particular situation.
Yeah.
So. Due diligence for 50, okay. The answer is the process of funding a project or a venture by raising a small amount of money from a large number of people, typically via the internet. Excellent.
So it appears everyone is very familiar with crowdfunding. Crowdfunding is obviously become much more popular in recent years. It's sort of an avant-garde type of, it's a means to raise money. Some people would argue that it's crowding out some early angel rounds because, obviously crowdfunding comes with a lot less strings attached. There aren't people who are putting money into your company and asking for control or, asking to have seats on the board. But it's become much more common over the last few years, and the federal government passed some laws to make it more permissible and make it easier for companies to do that.
I couldn't do this before you finish your response. What's going on here? There you go. Okay. Why don't we pick maybe one more, and then we'll go to Q&A.
40 for 50.
Excuse me? Potpourri for 50? Okay. Okay, the answer is a program startup applied to whereby they will be given a shared workspace, mentorship, educational advice, and potentially seed capital.
Engineering.
Exactly.
So accelerators obviously are becoming much more popular. They've been around for a long time, but it just blows my mind how many of them are popping up in the Boston area over the last few years. My opinion is they're pretty great places to go and hang out, and there's sort of a college vibe to it. There's a lot of people who are working together to try to take their ideas to the next stage. It's a great place where people talk about their successes and their failures and taking their products to market. You see, with some startups that I've worked with, sometimes they're actually surprised that some of these accelerators have a price. If you're coming to use their space, they're going to want to take some will take, 10% of your company in common. There's just a whole span of strings that are sometimes attached. To be quite honest, most of the time they're pretty lenient in terms of what they're asking for, but we have had some startups that we've worked with before who've been hesitant, and they're sort of leery of the fact that they're being asked, but they're being provided services, so, and I tend to think that what they ask is not that onerous for what they're giving to the startups.
But let me ask, how many of you are involved with an accelerator or incubator program? Okay. One of the things that an accelerator or an incubator program promotes is sharing of ideas. And, showing off your product, your development, but there's a downside to that. And I see this a lot. Someone will come to me, a company will come to me and say, hey, I'm in this accelerator program, I came up with this great idea, I want to protect it because I want to, be able to come up with an IP strategy for the company. Create a portfolio, hopefully investors will be interested in investing in the company. One of the first things I ask is, so where did you develop your technology? How have you been developing it? Many of them say, we have been working on this in the accelerator space. Been showing off to people, they've been asking for advice or input. Guess what? A couple of things there that kind of hurt you. First, what you've just done is you publicly disclose your innovation. And in the U.S., there's a grace period. So after you disclose it publicly, you have 12 months to file a patent application to protect it. But for the rest of the world, it's absolute novelty, meaning that if you disclose before you file a patent application, your ability to protect your innovation is gone. You just lost it. And so something to keep in mind is that if you have an idea that is worthwhile to protect, not only in the US, but internationally, and you're in an accelerator program, don't talk or don't tell anyone about what you're doing. If you have to, talk about it at a very high level. But just don't demonstrate, don't show, don't talk about it to anyone until you file a patent application. The other thing is that when you're sharing your idea, you're getting input from your colleagues within the accelerator program, guess what? The guy that gave you the input all of a sudden becomes a co-inventor with you. And he has as much right to that patent application if you were to file with his contribution in that patent application. And so just make sure that if you do talk, limit that, or better yet, if you talk to anyone and try to solicit their input, see if you can get them to assign any innovation or any contribution that they come up with over your company. So yeah, just keep those two things in mind. If you're in an accelerator program, don't talk, don't show, and if you have to talk at a high level, if someone contributes something to you, make sure that what their contribution doesn't make it into your patent application, otherwise they'll become a co-inventor on that. Okay? Sure.
What was the deal with 12 months?
Oh, so in the U.S., you have a 12-month grace period. So you just happen to disclose, your invention. You're talking with some friends. I had this great idea. This is how it's done, so on and so forth. Just happen to disclose that. Or you go to a conference, you do a presentation, talk about your innovation. In the U.S., you have 12 months before before you have to file a patent application. Otherwise, if you don't file a patent application within the 12 months, you lose your ability to protect your idea. Okay? And so, so a lot of people, when we ask that question, they start, okay, when did I first disclose that? And then if you just happen to disclose your innovation, there's one way of getting around or still protecting your ideas. That if you talk to an attorney, you say, hey, look, even though I disclosed that innovation, I came up with an improvement to that innovation. And so if there's an improvement and you haven't disclosed to anyone, then you can protect what you disclosed plus the improvement, and the focus is going to be on the improvement. That's one way to circumvent that 12-month rule. Okay. Why don't we
As a follow-up to that, let's just say a whole bunch of friends are sitting around, not accelerated, just
Yeah.
sitting around. And a friend comes up to me and says, oh, I got a great idea for an app.
Mm-hmm.
It should do this, this, and this, and this. And I already kind of had that idea sort of in one way, shape, or form.
Okay.
3 months later, I actually built the app. It's
Mhm.
become successful.
Yeah.
Does that friend have any legal right to that?
Well, it depends, right? In terms of IP, if you were to file an patent application, even though you had the idea and he contributed, or he thought he contributed.
He said one sentence.
Yeah.
He said, hey, I got an idea for an app. and-
Okay, and so if your patent application has, I don't know how familiar you guys are with the patent application, but if the patent application, in the claim section, that at the end there, where it defines the means and bounds of what your invention is, if there's a claim in your patent application that is directed to the subject matter that was suggested by your friend, then he has to be listed as a co-inventor, even though his contribution may be 1% of the whole invention. He gets to share in the entire patent application as a co-inventor.
Let's
And
say
so-
you don't fill out an application. Let's say you build the app and you make.
Then it becomes a contractual situation. Did you promise, was there an understanding that he gets to share in any success that you have? But if there's no understanding of that, and what you did is totally on your own, and he just came up with a high-level idea, I think you have a good chance of saying, but you didn't really contribute anything. Okay. Sure.
Some common mistakes that indie startups make.
You want to start with corporate first, and then I'll go
Yeah,
back?
I think not having a founder's agreement, I know we sort of already went over that, but you'd be surprised at how frequently people come up with, I see frequently someone coming to me and saying, I had this startup, we never got seed capital, me and 3 other people were working together, we went to such and such website, started a corporation, gave ourselves each a quarter of the shares, and now 2 of those people have gone off to California and they've started their other job. Now what do? And there's really not much we can do other than, it's very difficult. I mean, then you have to negotiate with them and try to get them to give it up. And I mean, that's really not a position that a startup wants to be in.
And I think part of that also is you and your co-founders have to set out at the very beginning, clear understanding of all the parameters and all the terms, because more often than not, and I've seen this a lot, even before the company gets going, there's some dispute between the co-founders, and then they have to dissolve the company. And that happens quite often. And so you should be clear in terms of what the expectations are, what each person's role may be, and that could be either in the founders agreement, or just at least memorialize some ways that each one of you clearly understand what's going on.
How long after coming up with the idea and publicly showing it do you have to file for a copyright?
Oh, so let me just kind of take one step back. That's a good question, but protecting the idea is not the domain of a copyright. It's actually the domain of a patent, so it's 12 months. That's what I said earlier. But so just let me take one step back. Patent protects an idea. A copyright protects the memorialization of the idea. So for instance, when you write a song, when you create a movie, when that idea gets put onto paper or some sort of medium, it gets automatically copyrighted. So purely protection of an idea is a domain of a patent. If the idea gets memorialized, it's the domain of a copyright. Does that make sense?
Okay.
Trademark protects the source or the identifier of the goods or the services, and the trade secret. Basically, keep something secret.
How long do you have for the copyright before you have to renew it?
Oh, no. So actually, I don't have a specific answer for that. But let me take it's for the copyright. As soon as you memorialize something, something is created on a piece of paper, it's automatically copyrighted. You can file for copyright protection, using various forms. I think it's the death of the author is, but I can follow up with you on that if you. I don't do a lot of copyright work, and so I still have an answer right off the top of my head. Okay.
So are you saying, that automatically something has copyright?
That's right.
So when you apply for it, are you just announcing it to the world, basically?
Exactly. So let's say this PowerPoint, right, at the bottom of the, I don't know, well, the person that created it, you can put C in a circle, the year, and the name of the company, or your name. It's automatically copyrighted. You don't have to do anything. You don't have to file for anything. The only reason you would file for copyright protection is if you think that you're going to go into litigation down the road. A copyright, registration allows you to recover attorney's fee as well as triple damages if you were to win.
Can you explain something more about the crowdfunding, like Kickstarter? What's the difference between a company have crowdfunding, one is acquired by some big company or company's IPO? What's the difference between a normal company or one have the crowdfunding?
What happens after somebody acquires a product that has been crowdfunded before?
Yeah, like
Facebook getting Oculus.
Yeah.
Let's see, I guess,
How do you pay for the
does the
people
crowd get anything out of it, or it's nothing?
I'm not familiar enough with that particular transaction.
Yeah.
So I know that there must be the same due diligence that you would do in any acquisition with regards to who owns specifically what, but I don't believe that they actually in that instance weren't receiving equity or anything. It was just money was put up, and the people who put that money up, I don't believe they actually got shares.
Yeah, typically they don't. I don't think that's the case. So, but it could be in certain instances where there's some exception to that, but typically that's not the case. Yes.
Which is better, angel funding or crowdfunding?
Well,
That's like asking, do you like cats more or dogs more? Right?
I think a fair point that a lot of angels would make that we've worked with is that when you are taking angel money, occasionally, and they argue that, they are sometimes people from the industry, and by taking that angel money, you're getting their mentorship and their guidance along with the money. So in some, arguably, depending on who is the angel investor, that's significantly more valuable than the money because they guide you in a particular direction.
So they'll ask for something in return. Right? And so whereas crowdfunding for the most part, there's not a lot being asked in return as opposed to an angel investment.
So what's the deal behind copywriting? If you put something down, like seed, name.
Yeah, so see the circle, year, and the name.
So the year comes first.
The year that you create. So let's say 2014. Right? So if you create this year, you put a C in a circle, 2014, and then your name. That's all you have to do.
Okay. My other question was, so that protects the more religion idea. So what if you have a foreign fixed document on a video game idea which you haven't made it yet, but you've written it down? You put C in copyright?
That content is copyrighted.
Companies like Nintendo, they have their it says like copyright 2004, and then it'll say copyright 2014. Do they?
Yeah. So most likely, they updated the content of that document. So once they update that, they put a new, the year that's been updated.
So you mentioned that filing a patent sometimes costs a lot of money. So for indie developers that have a new idea that haven't got any money yet, so
Great question. there's actually a strategy for you for those that don't have money. So instead of filing a regular patent application in the US, there's another application called a provisional application. That's actually one of the questions on here, but no one picked that. So a provisional application is typically called a quick and dirty application. There's no format required. I've received many invention disclosures from clients, basically on a sheet of paper, and they have to go and they do a talk the next day. They say, Jake, I got to give a talk on this tomorrow. Here's what I'm going to talk on. Can you file this piece of paper as a provisional patent application? The answer is yes, you can. So there's no format required. You file it. It costs $125 with the USPTO, and then a little bit of attorney's time, but it's very inexpensive. Keep in mind, though, that a provisional application, it's called quick and dirty, you should try to put in there as much information as you can, because when you convert that provisional application after 12 months, 12 months from the filing date of the provisional, anything new that you add into the regular application that wasn't in the provisional application will not be given the filing date of the provisional application. Okay, so it's given the filing date of the new regular application. So when you think that you're trying to beat somebody else up by pointing back to your provisional application, they're going to say, well, was that concept in the provisional application? If it's not, then it's getting the new filing date. Okay.
How long is that provisional patent good for?
It's good for 12 months. So once you file, by the anniversary of the filing of the provisional, you have to convert that into a regular US application, or else it becomes, it expires, it lapses, and you can't follow up. You can refile it as a new provisional application should you want to. One caveat to that is that if you disclosed it publicly, then it's no good. But if you haven't disclosed it, you can refile it as a provisional application. Yes?
And does it count as disclosing it publicly if it's still within your company? You've disclosed it, say you've disclosed it to some of your employees that are developing, and would that be?
But that is not public disclosure. But the line between what is public disclosure and what is not public disclosure can be very fuzzy sometimes. And I'll give you a great case, and this is one of the cases that we learned in law school. And this is the truth. The guy that invented the brassiere asked a woman friend to basically test it out for him. She wore the brassiere, obviously underneath her shirt, walked outside, no one could see the brassiere. Right? Someone challenged the patent later. Court found that actual action of wearing it, even though underneath your shirt, but walking out in public, that was public disclosure. So, patent was invalidated. So.
Wow. What about getting an NDA?
My response to it would be great. That's always a great, but in what context are you talking about?
Well, like if you're going to try to get play testers.
Okay, so yes.
Disclosing pretty much everything.
Exactly. So to get them to sign an NDA is a great idea, and basically preventing them from at least if there's an NDA, if they happen to disclose that, then it's a breach of contract. You have standing to sue them for a breach of contract. But it doesn't deter them from doing all the bad things that they may want to do. Right? I'll give you a great example. Had a client got a meeting with a company from abroad to come in to talk about the client's invention. Client asked the company from abroad to sign an NDA. Everything was great. Yeah. After the meeting, we found out that the company from abroad went out, even though they executed the NDA, went out and filed their own patent application on exactly what we disclosed to them. Fortunately for us, we had already filed a patent application on that before we went into the meeting, and so we still were able to point to that, as priority over the foreign company. And so getting an NDA executed doesn't prevent someone from filing a patent application on your invention. Just keep that in mind. So the best thing to do is file your application first before you talk with anyone. Yes?
How can a young startup protect itself from patent trolls who might possess overbroad software patents?
That's a great question. I don't know if there's a great way to do it, but one of the things that you may want to think about is as a company, a young company, whether or not you want to invest some money in studying the landscape before going down and developing the technology or the innovation. Sometimes it's very expensive to undertake a landscape study. That could cost you anywhere between $25,000 up to hundreds of thousands of dollars, depending on how crowded that space is. And so, it's tough to say. I mean, a lot of times you have to balance out the risk and the benefit of doing something like that. But in the software space, there's just so much innovation, so many patent applications that's been filed. So unless your attorney or yourself come across a patent that a troll may have, it may be tough for you to even realize that someone out there has some patent protection on that.
As a follow-up, what do you think the likelihood of software patent reform is? Is it at all likely in the next decade or so? Because I feel like I've heard a lot of buzz that people are acknowledging it's problematic.
For over a decade now.
Yeah.
But I think that really, and there's some movement towards some reform, but software is still available for protecting. And what's interesting is that in the U.S. it's much more difficult now to get patent protection. And for many companies, U.S. companies, if they want to file for software protection abroad, it's almost impossible because software, you think about it, is really about business method. Right? It's really a recipe, step-by-step of doing something. It's not about protecting the source code, it's about protecting the steps. And so that falls within the domain of business method. And most countries abroad don't allow you to protect business methods. So.
Yes. Is there a specific way you have to time date anything, or because most of the stuff that's required for at least engineering is to be in a composition notebook, so because it's tamper evident.
Yeah.
If you were doing things you print them out, is there a certain way you have to timestamp them?
No. I mean, I think that keeping a record of your research, your innovation, your discovery is a great thing to do, because if you have to prove who came up with the idea first, you can always point to the timestamp. But that used to be the case in the U.S. That's no longer the case, because the U.S. has moved from first to invent regime to a first to file regime to be in line with the rest of the world. And so now, if you invent something and you sit on it and you don't file a patent application, to the extent your neighbor came up with the idea after you, and he did it independent of what of any collaboration with you, and he runs the patent office and he files before you, he wins. So timestamping is great, but it's really not that critical anymore. It's now first to file in the U.S. Yes?
Copyright interacts with patent. If someone already invented something and has a physical item out there, and someone else creates something independent of them and then files a patent on it, who already invented it.
Mm-hmm. So that falls under whether or not the patent office or someone can point out to the patent office that the copyright is prior art against the patent application. So during the examination phase in the patent office, if there are any articles, publication, anything that's available publicly that demonstrate, illustrate, shows, teaches, discloses, something that's similar to what the patent applicant is trying to protect, those documents act as prior art and can basically prevent the applicant from getting a patent.
It has to be public, or can you have like,
Yeah, it has to be public. It has to be a public document.
so a personal document on a computer doesn't have,
No, yeah,
but an article in a newspaper or on a
Yes.
website on it?
yes.
So my question is, I've been working on this school project,
Mhm.
and we have a professor or advisor, and we get credit for doing this project.
Mhm.
So, and we have to do this presentation. So my question is, when we finish this game, this project, and we, does the school own the game or we own the game?
Well, it depends on what your basically your agreement with the school is. For the most part, most schools don't require undergraduate students to assign their innovation over to the school. But if you're a graduate student, a professor, an employee of the school, then for the most part, that innovation belongs to the school. But I don't think I've come across any school where they force the undergrad to assign it over. But it could happen, I just haven't come across it.
Also, we are, this is part of, or like, private, so
Yeah.
we have to do presentation.
Yeah.
So we consider it,
And who are you presenting it to?
like
The school? That's a public disclosure. I just want to take one step back. The advisor, okay? Because he's advising your group.
Yeah.
If for whatever reason he can claim that he's an inventor, guess what? He has an obligation to assign it over to the university. So you need to figure out, whether or not he actually contributed to any of the innovation.
Don't most of the time they just require a percentage of any profits you make from it?
For the professor,
Well, for if you create something on a company property, they would require a percentage.
it just depends. I mean, I'm not sure if I understand, exactly what your question is, but in terms of ownership, there's, as I said before, there's an assignment, requirement. So if you are under an obligation to assign, you have to assign it over. With most professors, even though they assign it over to the school, they still have the opportunity to, take their innovation and spin out a company, right? And to the extent that the company generates any revenue, it has to go back to the school, and there may be some obligation on the school to
Because I've been told if I come up with an idea but I'm on someone else's grounds,
yeah.
I have to, like I'm on school grounds, I have to,
Yes.
they have a right to get at least 20%.
No, if you're using school's property to invent school, laptop facilities, what have you, the school can basically say, hey, that's mine. It's unless the school says, okay, I'll give you 80%, and I just want 20%, then it's great, but for the most part, if you invent something on school property using school laptop or what have you, the school can just say, we own it.
So even if you're on your device on their property.
Depends on how much the school, and then it becomes a fact-finding situation. If you're just sitting in a classroom, I'd say no. It's pretty hard for the school to say, hey, look, we own that. But if you're using the school's lab, using the school's computer, doing all that, then the school has a much better argument in terms of whether or not they own the innovation. And we have less than 5 minutes, so last few questions.
What kind of things are considered in the founders agreement? More specifically for like a small
Generally, I think it's vesting over time. You want to make sure, if, I'm just saying 1/3, 1/3, 1/3. If you have 3 founders, they would vest on probably, I've seen on a monthly basis. That way, you're protected, because if 2 of the founders stay on for the long run and one leaves after 6 months, that person who's there for 6 months has only a small percentage of the stock. And they earned that stock because they were there for 6 months. The other 2 founders continue vesting, continue getting a larger portion of their shares, And it's just intrinsically fair that that's the way that it goes. That's the main purpose of the founders agreement.
Does the founders agreement have to be done in the presence of a lawyer, or do you bring that to a lawyer if someone violates it?
Enforcement, so it's a signed document where it essentially gives the contractual rights to the vesting over time of the shares. So it's all determined already, meaning the person simply does not own the shares unless they were employed long enough that those particular shares vested. It's an automatic document. It outlines what's going to occur over the next 3 years with regards to shares.
So you need a lawyer to get one, or do you need a lawyer to do one?
Nowadays, you just go online and.
They're out in the domain. I can't advise people to not use a lawyer.
But even if you pull down a document from one of these websites, right, we would recommend that you run it at least by a lawyer to make sure that all the terms and everything is appropriate. So.
They are generally in the public domain.
Yes.
You have a founders agreement with 2 names on it. Hasn't been signed yet. Later on, one of the founders wants to leave, but their name's still on the agreement, but no one signed it. Do they have any right, if what the existing one wants to rewrite it to either remove that person or?
I don't, that becomes an issue of state by state law as to whether or not they assented. There's all this case law, and those are the type of situations that end up in front of judges, and it's a fact, the totality of the circumstances. Generally speaking, I'd say it's not the best practice, and we try, obviously we try to get our lawyers, we try to get our clients to sign everything, and we spend a lot of time hounding them to make sure that they've had everything signed early on, because otherwise we've gone to all that work.
So right, there's a lot of like verbal agreements, but to get paperwork out of the way, and then, things go a different route, and, one of the founders wants to leave.
Extremely fact sensitive.
Yeah. And then perhaps you can agree to have a provision in there that allows, if it's unexecuted, for it to be modified. I mean, that could save you from all the headache. So. Okay, I think we're out of time. Thank you very much.